Last Sunday, the biggest part of Europe's law on artificial intelligence became binding. From that day, the software that sorts job applications, scores exams, and screens people at borders carries legal duties in all 27 member states, and a company that breaks them can be fined up to 15 million euros, or 3% of everything it earns worldwide in a year, whichever is larger. For the handful of practices Europe banned outright, the ceiling is 35 million, or 7%. And here is the second fact. The office that would actually issue such a fine is a national one, and in most of those 27 countries, it is not fully in place. By the middle of June, 9 countries had named the full set of authorities the law asked for. 12 were somewhere in between. 6 had named nobody at all. Both facts come from the same law. It set a deadline for companies, and it set a deadline for governments. Only one of them arrived on time. This is not an episode about whether artificial intelligence should be regulated, and we will not argue that question here. It is about a quieter choice inside almost every law you have ever lived under. Which of its deadlines has a price attached, and which one does not? Let's be precise, because this law arrived in pieces. It has existed since 2024, and it switched on in stages. The outright bans came first, early last year. Last Sunday, the main body arrived. The rules for what the law calls high-risk systems, the duty to tell people when they are dealing with a machine, and the part we are here for, the national enforcement machinery. High risk is not a figure of speech. It means the software that filters job applications, scores students, checks people at borders, and helps decide who gets credit or care. These are the systems that now carry legal duties, and getting them wrong can cost a company 15 million euros or 3% of its worldwide turnover. For a small firm, it is whichever of those two is smaller. Now, the other date on the same timeline. The same law gave every member state until the 2nd of August, 2025, a full year before all this, to have its enforcers ready. It did not demand a new agency built from scratch. An existing regulator can be handed the job, but it did demand something real. Name the authority, give it budget and staff, tell Brussels who it is, and publish how to reach it. That deadline passed a year ago. It is still passing. On the June count, 9 countries out of 27 had done the whole job. 12 had started it, 6 had not. Europe built its enforcement in 2 stories, and it is worth saying clearly that the upper one works. The biggest general-purpose models, the ones whose names you know, are supervised centrally, from Brussels by the Commission's own AI office. It can demand documents, run its own tests, and fine a model's maker up to 15 million euros, or 3% of turnover. One office, one address, and it exists. The lower story is national, and that is where almost everything touching an ordinary person sits. The hiring filter used by a company in your city. The system that flags your benefits claim. The tool that scores your child's exam. For all of that, the law does not send you to Brussels. It sends you to a market surveillance authority, a plain name for the office in your own country that inspects products and can order them off the market. That is not administrative trivia. Article 85 of this law gives you, personally, the right to complain about an AI system to that office. The right is written down, and it is the same in every member state. Whether it has an address depends on whether your government has named one, and the drafters saw this coming. The same law also orders governments to report back to Brussels on how much money and how many people those offices actually have. Here is the mechanism, and it is simpler than it sounds. When the law sets a deadline for a company, the consequence of missing it is built into the same law. Nobody has to decide to punish you. The percentage is written down, the authority applies it, and the arithmetic does the rest. When the same law sets a deadline for a government, there is no such machinery. A country that misses it faces one thing, what Brussels calls an infringement procedure. The Commission first has to decide to start it, then comes a formal letter, then a second and sterner letter, then a court case. And actual money, a financial penalty, only appears after a second court judgment, years down the line. Nothing about that is automatic, and nothing about it is quick. So put yourself inside a national ministry with a hiring freeze and 11 other deadlines this year. One of them charges 7% of turnover for being late, except that one is not yours. Yours costs a letter you can answer in 2 months. This needs no bad faith and no corruption to happen. It is arithmetic. And for some of the 6, it is not even arithmetic. It is a ministry of 40 people with no AI specialists to hire. The design problem is that the law cannot tell those 2 situations apart either. We know it is the mechanism and not this particular law because Europe has run the experiment before. Under the Digital Services Act, the Commission had to open procedures against 13 countries over the national coordinators that law required. Under DORA, the finance sector's resilience law, 3 more countries ended up in the same kind of procedure for not putting the rules in place on time. Different subject, same shape. What does the gap cost? Start with the person the law was written for. Your right to complain about an AI system is identical in all 27 countries. The address you send that complaint to is not. In 6 of them, on the June count, there was no address at all. Then the company, including the ones that did the work. A firm that spent 2 years and real money getting ready now competes against a firm that spent nothing and sits in a country with no inspector. The duty is identical on paper. The chance of anyone checking is not. Being early became a competitive disadvantage, which is the exact opposite of what the law intended. One honest caveat, because it matters. A missing office is not a permission slip. The duties apply everywhere from Sunday. They can be enforced later. Private parties can go to court in the meantime, and the central supervision of the biggest models runs regardless. The gap is not a shield. It is a delay, and someone decided how long it lasts. And the third cost is the one nobody advertises. When the same product meets 27 different chances of being examined, this is not really one market anymore. First design, tie the start to readiness instead of the calendar. In a given country, the duties would begin once that country has an appointed, staffed office verified against a public register rather than a press release. This is not exotic. European law already staggers obligations behind transitional periods, and banking supervision has used readiness triggers before. It has a real virtue: no dead letters. A company is never told to obey a rule that nobody in its country can interpret, and the honest firm is not punished for the absence of an inspector. The price lands on the wrong people. Protection would arrive last exactly where the state is slowest, so citizens with the weakest institutions wait the longest, the people the law was written for, and it gives every government a reason to take its time because slowness now shelters local industry. Second design, enforce centrally. Europe already does this for the biggest models, and it did it for the largest banks whose supervision moved to the European Central Bank after the financial crisis. One authority, one standard, no 27-speed patchwork. The price is distance. A single office would handle hiring software in Madrid, a school system in Tallinn, and a border tool in Warsaw, in every official language of the Union, with the Q that implies. It also pulls oversight away from national parliaments, the ones a voter can actually replace, toward an institution that same voter cannot. Uniformity is bought with remoteness. Third design, make the state's deadline cost something by itself instead of years of letters. Earmark money held back until the office is named, or Brussels stepping in as enforcer in that country until the national office exists, with an annual public scorecard of staff and budget built from the report the law already requires. The price is the steepest, and note who pays it. Withholding money from a government hits the citizens of that country, the same people the missing office was supposed to protect. So repairs 1 and 3 end up with the same victim. Automatic levers are also blind. They cannot tell a government that would not from a government that could not. And a lever this strong will be reached for again by other hands for causes you may like considerably less. Whatever you think of this particular law, take the question with you because it fits almost everything a parliament does. Any rule you live under has at least 2 deadlines inside it, one for the people who must obey and one for the institutions that must be ready. Ask which of the 2 has a price attached. That is not a technicality of drafting. It decides which half of the law actually happens on time, and it is decided by people you elect, the same people who choose whether their own deadline costs anything. So the next time a government announces that something has been regulated, ask the second question, the boring one. Who was told to be ready by when, and what happens to them if they are not? A law can announce a duty on any day it likes. It can only be enforced on the day someone is standing there.